Range of punishment is anywhere from 2 to 20 years in prison. So you know you're not dressed appropriately for court, right?
I didn't know that until I got here.
And I know you're probably going to get upset with me about the help that I'm going to give you, but I'm trying to save your life because the last time you use may be the last time you use. You already admitted that you're on heroin. That's not a good thing.
Today's case takes us inside a tense courtroom exchange featuring Judge Boyd and a defendant whose actions stunned everyone in attendance. According to the court proceedings, this individual appeared before the judge while under the influence. A decision that immediately raised eyebrows and set the tone for a dramatic hearing. What makes this moment especially unusual is Judge Boyd's approach. Instead of reacting with the immediate, severe penalties many might expect, the judge opted to take a different route. It was a move that surprised some observers and sparked conversations about whether unconventional methods have a place in serious cases like this. The situation leaves an important question hanging in the air. Should appearing in court while impaired be met with the strictest possible consequences, or can alternative actions sometimes be more effective? We're about to see exactly how Judge Boyd navigates this challenging scenario, with the defendant facing charges that could result in a sentence of up to 20 years.
Hello.
Hi, so you know you're not dressed appropriately for court, right?
I didn't know that until I got here.
All right, so next time you appear in court, you're not allowed to wear the T-straps. If you want to wear that, I know it's hot outside. You'll need to put on a jacket or something. You understand? All right. Court is calling 2024 CR 1728, State of Texas versus Angel Marie Bustos. Could I have parties announced for the record for the state?
Your Honor.
Defense?
Ninfa Gallegos Carrillo.
All right. And are you Miss Bustos?
Yes.
Counsel, you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Bustos, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it?
Yes, I did.
Did you review the document entitled A True Bill of Indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
You are, Your Honor.
Did you review the document entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
I didn't.
Did you understand you're charged with possession of a controlled substance, penalty group 1, 4 grams to 200 grams? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Yes.
State, any evidence? All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we would like to ask the court to some assistance with the fine. The state has already lowered the fine, so she can.
I'll probate the fine.
Okay, thank you, Your Honor. And also, she needs some help with drugs, Your Honor.
All right. Do you have any children?
I did. I got 2 of them that are already old enough, 18 and 19, and then my 2 youngest passed away. So no.
I'm sorry about that.
Thank you.
All right. When's the last time you had employment?
2019. I'm actually applied for disability.
All right. And what is your disability for?
I have mental illness
And what?
arthritis, 3 types of arthritis, and mental illness.
All right. You know, drugs is not helping that, right?
Yeah, I know. I've been try getting off. The withdrawals hurt really bad. I'm tired of it. I really am. I do it only just because of the pain, but I'm trying to get off of it. I do need help.
All right. So who is Melissa Marie Barrera to you?
That's my cousin's baby mama.
Okay. I have to do the mental gymnastics. And who is Mark Anthony Bustos?
My cousin.
All right. And who is the person you're with in court today?
That's my boyfriend.
All right. Where is he?
Right there.
All right. All right.
Okay.
Thank you. All right. And do you have any family support?
Just him.
Where's your family?
My mom died, my dad died, pretty much everyone passed away. I have my brothers, but one's in prison, the other one I don't talk to. So he's my family.
So that's why we're asking the court for some assistance, Your Honor. She needs some support from this court in order to help her with that addiction.
All right, this is what the court, and if you're drug tested today, it's going to be
It's gonna
positive.
be positive, ma'am.
All right, I appreciate your honesty.
It's clear this defendant is under the influence. Yet there's something about her that makes it hard not to feel a little sympathy. Her demeanor suggests she might have the potential to change, even if she's clearly facing serious challenges. From the way she carries herself, it seems she's had a tough past, and while not everyone struggles with substance use, most of us know what it's like to face difficult times. Legally, her condition raises the issue of competency to stand trial. If the court finds she wasn't in a fit state to understand the proceedings, it could affect the case entirely. The question is, can she recover enough to face the charges head-on, or has her current state already put her at a serious disadvantage? Let's head back into the courtroom to see how this plays out.
Now, I'm going to give you help today, and I know you're probably going to get upset with me about the help that I'm going to give you, but I'm trying to save your life because the last time you use may be the last time you use.
Okay.
So I'm going to do $1,000 fine. It's going to be probated. I'm going to give you 6 years deferred adjudication, proof of employment, or SSI within 30 days. There should be no employment as a home health care provider or with minors. There should be no unsupervised contact with minors. There's going to be regular reporting by Zoom or in person. We're going to do the UA hotline, going to do a TAP evaluation, felony drug court referral, and Esperanza court referral. That's going to take place in custody. I'm going to ask for 120 sober meetings in 120 days. There should be no contact with Melissa Marie Barrera, Mark Anthony Bustos. Going to want field visits 1 time per month until further notice, and 200 hours of community service restitution. Probation, is there anything else she needs?
Well, it's not just me, Judge Boyd genuinely appears to care about this defendant. Many judges would have reacted instantly, handing down the maximum sentence for arriving in court under the influence without even pausing to ask why. But here, Boyd seems to recognize that what this woman might need most is guidance and support, not just punishment. That kind of compassion is rare in a courtroom. Instead of simply treating the case as another file to close, the judge seems willing to consider the human side of the problem. Drug addiction remains a major issue in the United States, and history shows that prison alone rarely fixes it. If more judges looked beyond the immediate offense and focused on rehabilitation, we might see fewer repeat cases and more real recovery. But what's your take? Is this a step in the right direction, or should the law come down harder in situations like this?
I need referral first.
Yes.
Assuming outcome, I can't have 2 referrals.
No. We'll do felony drug court first.
Okay,
And if she's not accepted there, which if you're honest with them, they'll accept you.
Okay.
And then if she's not accepted there, we'll do Esperanza court.
thank you.
All right.
Nothing further.
All right. Is there anything else you need from the court?
No.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, I did.
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right. We're off the record. To be successful in this court, you need to make sure that you're in contact with probation. If you feel it as though probation is not addressing an issue with you, you can always come in this court. We'll be here.
Okay.
All right. The other thing is felony drug court is a good program. It's something that you need. You're probably going to need inpatient treatment. But if you are accepted to felony drug court will be monitoring your situation. And they have a judge there, and that judge is Judge Glenn. He'll be monitoring how you're doing.
Mhm.
The only time I will see you is if you're graduating, and I'll show up to your graduation, or if they send you back here because they say there's nothing else that they can do.
Okay.
All right?
Okay.
And if you want me to show up at your graduation, I will definitely show up to your graduation. Okay?
Thank you.
So what's going to happen today is the deputies are going to take you into custody. If there's anything that you want to see, want to give to your boyfriend, just let them know.
How long is it gonna be,
Yeah.
Because one, you already admitted that you're on heroin. That's not a good thing. Because the last time you use could be the last time you use.
Okay.
And because here's the thing, if you could have, you would have at least came in the court sober. So what will end up happening is felony drug court, it's Tuesday. They'll probably be able to get to see her because I'm going to sign the order immediately for them to interview you. So they'll probably be able to see you before this week is out, and you need to let them know that you're interested in being in their program, and then they will take over supervision. If they think you need inpatient treatment, they'll give you inpatient treatment. If they think you need outpatient treatment, they'll give you outpatient treatment. Okay?
I am often critical of court rulings, especially when it feels like drug offenses don't face fitting consequences. But here, I'm impressed. The defendant received 6 years of adjudication, giving her a chance to recover without immediate prison time. As a mother of 2, this could be a real turning point. The bigger issue is how addiction is handled in the US, where punishment often outweighs rehabilitation. It's encouraging to see a ruling that focuses on recovery, and if she uses this opportunity well, it might inspire others to seek help too.